where the ad hoc committee set up to probe Public Protector Mkhwebane met today and set a date for her appearance. Our parliamentary correspondent Lula Madlepu attended the meeting.
The Constitutional Court's decision not to entertain Mkhwebane's rescission application to halt her removal from office was the last resort, but she remains on a war path. She laid criminal charges last week following a leaked SMS sent to lawyers of Parliament weeks ago, preempting the outcome of a rescission application.
This leak, if established, clearly poses a threat to the very fabric of our democracy, the rule of law, and much-needed independence of the judiciary. The country, therefore, has no choice but to get to the bottom of this matter. It cannot be swept under the carpet. It cannot be business as usual.
Mkhwebane says her office has invoked the Public Protectors Act to also investigate the leak.
It is yet to be clear whether the leak came from the members of the Constitutional Court, the administration within the judiciary, so we will have to also investigate and assist in this particular matter. So insofar as it may have come from the administration who are employees of the Department of Justice, then the Public Protector has cleared jurisdiction. Insofar as it may have come from a member of the judiciary, the constitutional and statutory exemptions contained in Section 182(3) of the Constitution and Section 66 of the Public Protector apply respectively. I have therefore been advised specifically to steer away from the investigating relating to court decisions or performance of judicial functions by any member of by any court of law. But then this investigation will strictly be confined on issues of alleged maladministration, corruption, or other criminal conduct.
Judges Mehta says the criminal case will have no bearing on the inquiry into her fitness to hold office. It says the Constitutional Court's dismissal of Mkhwebane's rescission application has various consequences.
The first consequence is that the case that was scheduled to be heard in the Western Cape High Court on the 18th and 19th of May falls away. That's because the dispute which gave rise to the case has also now been resolved, and which means that the case is moot. The second consequence is that the Parliament may now proceed with the inquiry into the fitness of Public Protector Mkhwebane to hold office. The related consequence is that the President may also place Advocate Mkhwebane on suspension pending the finalization of the Section 194 inquiry. Although the Public Protector has filed a criminal case relating to the SMS that was sent to Parliament's lawyers, this does not affect the Section 194 inquiry in Parliament, and it may proceed regardless of the criminal case.
Parliament says the dismissal of the Public Protector's rescission application is welcomed.
So what we are waiting for following the decision of the Constitutional Court, which we are pleased with, because it is important that the powers of Parliament to hold the heads of Chapter 9 institution accountable are always protected, and we are pleased with that. And therefore what we are waiting for is a decision of the Public Protector with regard to the current case that is before the Western Cape High Court, because the rescission application that has now been dismissed has got a direct impact on that particular case, because she sought to interdict the ongoing Section 194 inquiry pending the outcome of the Constitutional Court, and therefore we need to know what is the next step with regard to that.
Members, the National Legislature is hopeful that the investigation into Mkhwebane's fitness to hold office will be concluded before the end of the year.
The Section 194 meeting is continuing with its inquiry, and like we said, there's never been anything that stopped it from proceeding with its work, and we are hopeful that within few months they should be able to conclude their business and make recommendations before the House for the consideration of the sitting of the National Assembly. Of course, for a decision to be taken, it will require a two-thirds majority, so it will be up to the members of the House to agree or to disagree with the report, its recommendations and its findings.
And to achieve a two-thirds majority to remove a public protector from office would require 266 to 267 of the 400 members of the National Assembly to vote in favor of a recommendation for her removal. Mercedes Basent, SABC News, Parliament.
That was our colleague earlier. The Section 194 committee investigating the public protector's fitness to hold office did have a meeting today, and at which they discussed or arrived at a decision, date rather, as to when they will call her to appear in person, and that's the meeting that Lula Madlepu, our colleague, attended, and she brought us this report. Okay, that package is not there yet, but committee, both of them, of course, in the piece we wanted to play you first. Before we spoke to them, we do have Hanif Hendricks, who is the leader of Al Jamaa, and we also have Vuyelwe Tuzungula from the African Transformation Movement. He is the leader of that party. Good evening to both of you, and thanks very much for your time.
Oh, it's a pleasure. Thank you very much.
Well, you did arrive at a date of, I think it's the 3rd, if I'm not mistaken, of July. And Mr. Hendricks, if I may start with you, are you happy with how things proceeded at the meeting the committee held today?
Look, procedurally, we are quite happy with the transparency and opportunity, and we have received the minutes of the meeting. And as you know, that enough time has been set aside for evidence to be led. In fact, there are 2 extra window periods in case more time is needed, and it looks like the final hearings will be held in the month of September, and members of Parliament who serve on the committee have been asked to take time out from their constituency work, which is normally 6 weeks when we go into the communities, and now we have to break away and attend these hearings. This is now subject to the Chief Whip's approval, but in my view, our work in the constituencies, in the light of the floods, in the light of the unrest that we had, in the light of the looting that takes place, we need to be in our communities and not waste our time, with this particular matter. You have already mentioned that nearly 260 votes is needed. You also know that 60 members of the ANC walked out of the last meeting, and 2 or 4 cabinet ministers did not participate in the proceedings moving forward. But then, on that occasion, it was just a normal majority that was needed. So I would imagine that when the matter comes to a vote in September, those 60 members of the ANC and 2-3 cabinet ministers will either walk out of the meeting or they will vote against a proposal. If, for example, there is a recommendation in the report that the public protector will be removed. So for Al Jamaa, we all 40 political parties are now dragged into this. As a member of Parliament, we have to do our duty. We will attend the hearings, we will participate, we will debate. But for us, this is a futile exercise, and it is wasting everyone's time, and it's very expensive. And also, we have a principal position on removing, for example, a head of the CCMA and a head of this institution, which is supposed to resolve matters speedily, and then also we find that the normal high standards of the courts are not applied, and here Parliament is going to judge the public protector in terms of the high standards that one expects the court.
Okay, Vuela Zungula, from your vantage point?
Look, Vuyo, if you are talking about the office of the public protector, you are talking about a quasi-judicial body in which it makes certain reports or certain recommendations in accordance to the law. Just like it happens with the judges, those judgments can get to be overturned in the future by higher courts. That is in accordance with the law. Now, the process that we are finding now, it is a process whereby it was clear from the onset that we are dealing with a case that is targeted towards an individual, which is Advocate Mkhwebane. That is problematic to our democracy because it means we do not have a parliament that creates laws for the betterment of the institution of parliament or Chapter 9 institution or democracy itself. Rather, we've got a certain witch hunt that has been directed towards a certain individual. Now, the rules of parliament clearly state that no member of parliament may reflect on a matter that still awaits judicial, in which a decision in a court of law, it is still pending. Now, how that has been interpreted and understood in the past is that if there's a pending case in the court of law, then Parliament must cease or Parliament must postpone or suspend anything that it was going to do up until the course of laws has pronounced and come to a finality. However, in this case, we've got Parliament that is ignoring its own rules. Remember, Boyo, here on Rule 89 of Parliament, we're not talking about a rule that was decided by the courts or a rule that, Parliament was in duress and they were forced to make this rule. We're talking about a rule in which Parliament itself said, in doing our work as Parliament, we must respect the courts, and if anything is before the courts, let us suspend or not proceed with any matter up until a finalization. The Parliament knows exactly that later on in this month, there is still a pending court case in the Western Cape High Court. However, they choose to proceed. They do know that the Chief Justice as well is leading an investigation regarding this leaked SMS, which might show, if there's any form of judicial corruption. But Parliament refuses to understand the gravity of the seriousness of that leak, and why is it important for Parliament not to jump the gun, and Parliament must be seen to be objective. It must be seen to be, it must be seen not to be playing the person, but it must be seen to be principled. In this entire process, we've not seen that.
Well, in the background piece by our colleague Mercedes Besant, you saw some legal fundis saying what you've just said. In other words, the latter part of your argument is in fact not necessarily true or doesn't hold. In fact, I'm going to play another clip from our sister show Full View earlier, Professor Pierre Deforce talking about, sharing his own views on the back, of course, of the meeting you were part of today. Take a listen.
You can only make a rescission application if there was a court judgment in which a serious, egregious mistake was made. Here there was no judgment. The court declined to hear the case. They said there was absolutely no prospect of success because the grounds were, for whatever reason, my interpretation is because the grounds was really an attempt to appeal the judgment of the same court to the same court. So I don't understand how there can be another application. There's no provision for it in our law. It has never happened in the history of South Africa. So I really think that she and a lawyer should think before they proceed with this, because it is clearly an abuse of the process to stall the impeachment procedures that is continuing in the National Assembly.
Mr. Zungula, Pierre Deforce short and sharp and to the point. I mean, there's no judgment, and the court that she went to earlier did say that there were no prospects, of success.
But Boyo, if you're talking about purity force, everyone knows how biased he is towards advocating Mkhwebane. You can never get any form of principle from purity force when it comes to advocating Mkhwebane.
Freedom under law said pretty much the same thing.
Look, Budvoyo, we are talking about people who lack objectivity in our country. People have got a certain narrative, and that narrative has always been that Advocate Mkhwebane is not fit for the job. She must go simply because she did not, fear the powers that be. She made findings against a sitting president. She made findings against the darling of white monopoly capital, which is Pravin Gordhan. That is why each and every of these NGOs would always not be objective when it comes to her. Secondly, on the issue that he has raised on to rescind the judgment, even previously there was never a thing which is people did not understand that after a constitutional court has made a decision that there could be an application to rescind that judgment. Now, he can't be saying it has never happened in law, or it is something that is nonsensical, or it is something that is unheard of, because we don't know. Let us allow the courts. What we are saying as the ATM is very simple. Let us allow the courts to make a final determination. When the courts have made the final determination, then Parliament can proceed with the work without jumping the gun and without appearing as if there is a particular witch hunt. Otherwise, immediately Parliament is rushing, to impeach the public protector. Then it raises a lot of questions as to, are we not weakening the institution of a public protector if it happens that a sitting public protector makes unfavorable decisions or recommendations against the powers that be? Then the next public protector will also be pushed into a box of being fearful against the powers that be. So that is why, as political parties, we need to guard, the process, make sure that it is principled in accordance to the law, and most importantly, there is no witch hunt.
And if Hendricks, I know, you hold the position that this is a waste of time and money, that all of you as parliamentarians should be focusing on better things like floods that you mentioned. But notwithstanding your reservations and your position on the matter, let's talk about what is going to be done. And having heard what your freedom under laws, your Professor Pierre de Forces had to say, do you not think that they...
I think the public protector must have a day in Parliament. This is one matter where, the judiciary doesn't rule, Parliament rules, and that should be the case in South Africa. You can't have a country ruled by the courts, you must be ruled by Parliament, because it's Parliament. It's the people who elects Parliament. So for once in our life now, the final decision will be taken by Parliament. And you have heard my views that I don't think that they will get the 2/3 majority. No one is going to vote for a DA motion. ANC members won't vote for a DA motion. So we will have to wait till see until that happens. But in the meantime, I think you have a point, Vio. Let the public protector, respond to the charges against her. I just hope that they will hold to court not only the public protector, but the 200 staffers that work for her. I've had a few cases that were dealt with, and the decisions were signed by the public protector, but dozens and dozens of people were involved in the inquiry, and I don't even think in some of the matters the public protector was actively involved. So we're talking about an institution consisting of support staff, the public protector, the buck stops with her, she signs whatever findings is made, she decides on the sanctions, that's her job. But the work is done by many, many people. And